process that exists in the magistrate's court. But the problem with that is that then the safeguards defeat the purpose of expedition as espoused by the Attorney General and the Honorable Minister in the office of the Attorney General. You add another layer of legal arguments, and therefore it will bog down the case law and not produce the results that the government would like that would come from this legislation. My learned colleague is well aware also that courts are very, very reluctant to review decisions of the magistrate by way of judicial review. So that safeguard, while it may exist, it's not practicable. And the best person, I have to disagree with the Honorable Minister in the Ministry of the Attorney General, the best person to make the decision is the specific defendant and their counsel, their attorney, to defend themselves, not a judicial officer, not a magistrate. The best person to determine how to proceed is the defendant and their representative. This bill, an act to amend the Summary Courts Act, Chapter 420, to remove the requirement of consent for the joinder of complaints in summary judicial matters, it states, and in the essence of the bill, it's only one clause, and in the clause there are many questions that need to be answered. And I quote Clause 2, where two or more complaints are made by one or more parties against another party or other parties in the same matter, and the complaints in that matter are founded on the same facts, the complaints may, if the court thinks fit, be heard and determined together unless the court determines that separate proceedings are required in the interest of justice. Firstly, in this clause, what is the understanding of a matter? A matter may be as individual as fingerprints or DNA. So while we have processes in the magistrate's court about summary facts and summary evidence, what is determined a matter is individual per defendant. So what may be a matter to the Honorable Minister in the Ministry of the Attorney General and what may be a matter to me, even though the summary facts may seem to be the same, may be interpreted in different forms or fashions dependent on the defense that I would like to put forward with my learned counsel. So any attempt to generalize will meet a weakness of individual justice, which is what we must put at the forefront of our minds. Secondly, the same facts. I proffer that facts are never the same for disparate individuals, even if the charges may be the same or occurred at the same time in the same place. Each person arrives there with a different mentality, a different mens rea, a different understanding, a different decision-making process, different thoughts. So to try to lump defendants all in one would intrinsically mean that they are at a disadvantage when attempting to receive justice. Thirdly, if the court thinks fit, while we may have a lot of respect and understanding for our institutions, the court in itself is made up of human beings, and we are all frail. So to give this great power unto human beings because they sit in a position may not present the best option for individuals who are facing a charge and an opportunity to defend themselves against wrongdoing. Fourth, and this is the most important part of the clause, it says, in the interest of justice. Yet the Honorable Minister in the Ministry of the Attorney General listed at the end of her presentation all of the reasons and the rationale for this bill, and all of them put a higher level of import on expediency, removing backlog, getting through the process. Yet in the clause itself, it states in the interest of justice. And I put it here in the Senate today that this bill and this clause, this law, this attempt to put expediency above justice does not fit in with the constitutional remit, with our democratic principles, and how we believe that justice must be fair and all must get a fair shake before the courts. I'll just make a few points. I won't be long. And I hope that the government would listen carefully and that at the committee stage, some amendments could be made. The bill removes the statutory right of a defendant in criminal proceedings to A, be informed of his right to have his proceedings heard separately from other proceedings which are predicated upon the same facts, and B, consent to having his matter heard together with another matter. It now puts the responsibility in the hands of the court to determine if matters should be heard together by applying an interest of justice test. Should that be the test? Is that what we want? Individuals may be charged at the same time, same place, same event, but each individual will have a different defense to put forward, and they could be prejudiced if they are lumped together with others. So I think while the objective is good, we would all like to see a removal of the backlog. I think there are other things that could be done before this bill is passed in this way. Secondly, the underlying philosophy seems to be that the summary criminal cases before the courts will be expedited. If similar matters are heard and determined together, that's what we feel, that's what we think will happen. Respectfully, that is a serious fallacy, which ought not to be encouraged. Justice must not be sacrificed on the altar of expediency. If we carry the principle that is being espoused here to the fullest extent, we could believe that we could turn the police into judge, jury, and executioner. Wouldn't that be fastest? That will get rid of the judicial process altogether and let the police or the army or the Coast Guard handle matters in how they see fit. They see somebody doing something illegal, then let's fast track it. Let them handle it. That is carrying it to an extent that may seem ludicrous, but it's said to give you an idea of what the government is trying to do. Someone's rights and freedoms are very important. So if you chip away at them, and you chip away at them in order to free up your system, to present an idea that you are doing more, but you are impacting on the individual rights of citizens, it is very dangerous and carries you down a path that could end up in the ludicrous, with judge, jury, and executioner being the police, the army, or the Coast Guard. For we must appreciate also that the hearing of a criminal matter together is not as easy and straightforward as it sounds. Court resources and facilities are in deplorable state. We've seen the courts in San Fernando, we've seen the courts in Arima, we've seen courts in Port of Spain. They are under pressure. They've been constructed so long ago. They find great difficulty in even providing comfort for the attorneys who are present. They put pressure on the security forces to get in people, to make sure that people respect the court. We don't have the facilities to even, at this time, go through cases with one defendant. What about if you had 10 defendants? 10 defendants in one little courtroom with 10 attorneys and the prosecution. Where would they fit? How would we manage? It is just a totally impractical in the real world, in the condition that our judicial system and our judiciary is in at this point in time. If you were to say that we should build more courts, okay, well, government, build more courts, please, or rent some more courts. I mean, the Honorable Attorney General may have a building to rent, so we can rent it. Tower D is empty. Why not utilize that space? Create courts, create space. because this cannot work in the system and the infrastructure that we have now. What about the vacancies that exist in the DPP office, in the prosecutors, in the court, in the magistrates, in the judiciary? These vacancies must be filled before you can proclaim and implement this. We will pass a law that will just create more problems than provide us with benefits, because we simply cannot manage. Managing a case with multiple defendants is very, very difficult. As an example, we can move on. It may, a matter, for example, if it involves 10 defendants, that would mean the court, right, would require accommodation and so on. Secondly, there can be untold prejudice in having matters heard together. This is a very critical point, simply because there are some underlying facts. For instance, several people may be held and charged because drugs are found in the same house. These persons may include actual occupiers of the house, visitors, or people who simply came to work at the premises, someone who came to fix and clean the fish tank and happened to be there when police came. Each person may have their own reason for being at that house, and therefore different defenses. However, trying cases together may increase the prejudice against the innocent parties, because the evidence against the guilty may be so overwhelming and obvious. Suppose a young boy is liming with some fellas who were reputed gang members, and they have a list of charges, but they're out on bail, and he is going to now be charged with all of these career criminals. Don't you believe that being charged together would not provide him as an individual, or her, with that opportunity to receive justice? His case could be prejudiced by that, and to remove that option from him and his learned counsel, I think we are overstepping our bounds here as legislative members. It is not enough to simply say that everyone has a fair trial. That's not enough. Trials are conducted by magistrates and judges who are human beings and can make errors. That's why we have different levels. That's why we have appeals. That's why we have our counsels on both sides. That's why we can go through documents. We can make arguments. That's the basis of the judicial system. Why? Because presenting arguments brings forth evidence and you search for the truth. Trying to get quickly to a decision may not provide you with the truth. It may expedite. But if you are someone who ends up being found guilty because the government wanted to move quickly and your case was not heard properly because you were lumped together with others, you would not be so happy with this law. Appeals take a long time before they're heard, and therefore it is important that legislators get the process and procedure right when approaching the summary court procedure. And going back to the Honorable Minister in the Office of the Attorney General, if, for example, the arguments are put forth by an attorney and they are denied the right for individual trial, that gives another layer of possible appeal, and that would extend the backlog and bog down the courts even more. There is the question of natural justice, and this is very critical, and protection of the law. The legislation as it stands specifically engages the defendant in the process. It requires him to be specifically informed of a right to have his matter heard separately. While the legislation is removing the right to have matters heard separately, the way this legislation is drafted there is a risk that the court may take the decision to hear the matters together without seeking the view of the defendant, and that risk is too much to bear. While we may have a lot of faith in our magistrates, they're human beings. Some might be late, some might not have their coffee, they might want to get through their backlog of cases, they may have a football game to go to with a grandchild playing, and they may make an error, and that is dangerous. While the legislation removes the right of the defendant to be informed of his or her rights, it should have replaced that right with a legislative provision that ensures a defendant is specifically informed of the decision to hear matters together and provide him with an opportunity to be heard. In relation to the decision, legislation should be specifically drafted to state that no decision to hear matters together should be taken, and this is very critical. No decision should be taken without specifically informing the defendant of that decision, seeking his views on the decision by affording him a right to be heard. This right to be heard is very critical. And then providing reasons to the defendant if the judicial officer makes a decision against the defendant's views. Now, the Honorable Prime Minister should know very well about the importance of this rule of natural justice, because he was a victim of this, as he was not informed of a case file that had been sent to the DPP on a matter involving serious allegations of corruption involving land at a certain date in the past. But 25 years later, the police have not completed or restarted that investigation. But the Honorable Prime Minister, the file and the case was thrown out because of lack of process, lack of ability to answer, not asking a question, not being able to put forward a defense. So we must be very careful how we move forward with this bill. Finally, different human beings have different personalities, different mental strength, different character, different self-esteem. As a coach, I can tell you, some athletes you can shout at, buff them, and they take that and they move faster, harder, and it doesn't bother them. Other athletes, if you look at them wrong and they are not happy, they will cry, they will go into a shell, and they will not perform, because every human being is different. So therefore, when you group defendants, there's a risk of capitulation midstream. So if you group some defendants, and then under pressure there's one defendant who just isn't happy being in the court, isn't happy putting on shirt and tie, and eventually they crumble and they falter, they change their story, they crumble under cross-examination, or they even just say, well, I am guilty, I want this thing to be over. And in midstream, when that person with that different personality does that, whether innocent or guilty, but they succumb to the pressure of the circumstances, and those in the courts will understand that not everybody likes to go up and down a court step, then that will prejudice the case for the others midstream, and that's very dangerous. So I would like the Honorable Attorney General and the government to look at this. The United National Congress, we understand what the government is trying to do. We need to get swift justice in order to assist in the crime fight so that criminals would not be so brazen. While this may be a summary offenses act, it will also present or prevent the problem of young people staying in remand and becoming hardened criminals, waiting for their cases to come up for summary offenses, a little portion of drugs, or however they're charged, and they end up in remand because they cannot make bail. We understand that. However, there are many steps that the government could take to improve the speed and efficiency of the judiciary. Building more courts, accessing more buildings, providing more equipment, filling out the establishment, jobs on the establishment, providing more resources to the judiciary before they start to trample on the rights of defendants, because everybody is innocent until proven guilty. So we are here today, and we will sit in committee and see if some of these clauses, some of these recommendations that will be put forward from the opposition could be taken on board, because the right of our citizens to a free and fair trial is the most important. We want a lawful society. We want a society based on discipline, respect, love, and togetherness. But we cannot do so by putting some people at a disadvantage to be called guilty while others get away scot-free. Thank you very much, Mr. Vice President. God bless.